Hi everybody, welcome to our debt recovery seminar, some advice on how to get your invoices paid. My name's Jodie Thomson, I'm a practice leader in LegalVision's disputes team.
My name's Simon Hillier, I'm also in the disputes and litigation team as a lawyer.
Simon and I work a lot on different sorts of contractual disputes, but including debt recovery, so we've got a lot of experience in the steps to work through for companies and businesses to get their unpaid debts recovered. We're going to take you through some of the preliminary stages. So the things that you can do yourself as a business without needing a lawyer's help and without going to court. And a lot of that is a bit of homework to start looking at the debt and the other party involved and some early communications.
And the structure of today's talk is, firstly, we're going to talk about what you need to do to identify a debt, the initial sort of processes and steps you can take to try and recover something quickly. We're going to talk about legal demands and negotiations. And then at the end, we'll touch a little bit on the court processes very briefly, just so that there's an understanding of what comes next. And after that, we've got some time to answer questions as well.
So if you've got an unpaid invoice, and these sort of things can be a real cash flow problem for a business, whether you're big or small. It's often difficult to know what options you should take. And as we've said, there's a lot you can do to start with. The first thing we recommend, before you do anything, once you've realised that something's not been paid on its due date, is to step back and do a little bit of homework and investigation just to make sure you've got all of your information in order. The first step is having a look at what the agreement is between the parties. That doesn't have to be a formal signed contract. It might be, you might have a supply agreement or a more formal agreement. You might have a signed credit application. But if you don't, that's okay. The agreement can be formed by an exchange of documents like a purchase order and an invoice. And in some cases, it might just have been an exchange of emails or at worst, a conversation. There can still be an agreement formed that you're entitled to claim money on.
And in terms of what's contained in those agreements, one of the key things you need to look for is who actually are the parties. Is it an individual who's a sole trader? Is it a company? If it's a company with lots of different entities, which entity have you actually entered into the agreement with? It's important to look at that first, because any subsequent steps you take, like sending a letter or ultimately going to court, if this is sort of the last resort, you need to be correct in identifying the legal entity that owes you the money. And in theory, that should be covered off in whatever the terms of the agreement were, usually by way of an ABN or an ACN.
It sounds obvious, but we really stress the point because it's something that we see a lot of businesses either making mistakes in or just not being clear on. And the fact is that if you want to pursue a debt and if you need to take it to any form of court proceedings, this is really important, because if you start going after the wrong legal entity, then there's nowhere you can go. We see, for example, a lot of businesses accepting credit applications, and you might not ever have need to look at this closely until there's an unpaid invoice or a dispute. But a lot of other parties might just write down their business name. So you can't pursue legally a business name. You need to know if it's an individual or a company that's actually operating the business, and it's important to have that clear before you take any next steps.
And another thing to think about in terms of who owes the debt, it can sometimes be more than one person or entity. A common situation that might arise in is if someone provides a personal guarantee. So that what that is if a company is entering into some kind of transaction, but part of that deal involves the director of the company signing some additional paperwork that says they're also liable for any debts that may accrue. So what that would mean is from the outset, you'd be able to pursue both parties at once, and it often can be a bit more persuasive going after an individual than the company that they could otherwise potentially sort of sit behind and be separated out from. this actually came up with me yesterday. I was talking to a client. He was trying to figure out why someone had put a caveat on his personally owned house, and his company owed someone some money, but we were looking at the contract. We couldn't figure out, this contract doesn't give them the right to put a caveat on your personal property. But then I told him to go digging, and he did find some forms he'd signed a few years ago where he had guaranteed as a director of that company. And it meant there were all these extra rights for the other party, that because he owed a debt, they were able to, secure over his property. So there's all sorts of legal pathways available to you, but it comes back to the documents, and it's really clear to look at, who signed what, who can you make a claim against, because that really changes your strategy from the outset.
And if there is a guarantee, now's the time to pull it out and put it on the table. And from this point, it's about persuasion and a bit of pressure and leverage. Once you've done that homework and you've got clear that there's an agreement, and there's been an agreement for services and they haven't been paid for, and you know the parties that you're dealing with, and if there's a guarantee, you've got them on board as well, then you can start taking some steps yourself. Look, our biggest advice at this stage, and this is certainly something we recommend that businesses do themselves, it does of course depend on how big you are, the number of debts, and what kind of resources you might have available, but the same principles apply. And that is firstly to keep the lines of communication open. We don't recommend, even when things move down the track legally, to take an aggressive stance. It's more likely to be resolved. You're more likely to get money if you can keep those lines of communication open and certainly keep civil and professional about it. And follow up as a starting point, whether it's by email, telephone, text, whatever the relationship or practical option might be for your business. Give parties the benefit of the doubt. We're all a bit conditioned these days not to do anything until we get a reminder text, whether it's a doctor's appointment or otherwise. We see a lot of matters get resolved really quickly and easily because there's been an oversight or something missed in an inbox. So it sounds obvious, but it's a really quick and simple way to get things resolved from the starting point.
And something you can think about too is setting it up at your end, so you've got a process to follow, or your accounts team has a process to follow, where the moment an invoice becomes overdue, perhaps an automated email could go out, and then 5 days later you could call them up or something like that. So you're addressing a similar process every time. So you can figure out early, are any of these just there's been a delay with administration or an oversight due to someone not being organised, or you take those steps, you're still not getting a response, and then you might need to look into sort of taking further escalated action. The other thing that might crop up at this stage is we think about debts and disputes differently. A debt is just, there's almost an assumption that it's money that's owed. In contrast, every day people will be arguing that actually the money isn't owed, and it's a whole separate question and process if you're chasing up someone for invoices and then they turn around and say, actually I dispute the sum, or I dispute the basis that you're claiming is owed. At that point it's a contractual dispute essentially, and that's not really what we're talking about today. But part of the reason you want to be really rigorous and just following up your debtors is it's useful to gather information. It's good to figure out whether or not it's someone who's just not paying because they're slack or they're tight for cash flow themselves, or whether they've got to be in their bonnet and they want to actually argue about it, so that you can then think about how you're going to approach it moving forward and what kind of resources you might want to dedicate to trying to recover if there's a bit of resistance.
So yeah, that's something that we deal with a lot in disputes, and when we're talking to clients, the early stages are very much about information gathering. It's not so much going in with a sledgehammer to try and scare the life out of the other side. It's actually trying to find out what's going on. And in terms of differentiating between a debt and a dispute, you could look at it that a debt, there are two types of debtors, the ones who can't pay and the ones who won't pay. The ones who won't pay have some kind of issue. And as Simon said, that falls into a dispute. And that's quite a different strategy and tactic that we're not really going to cover in the webinar today. We're looking at ways to help you with the other category, which is the ones who perhaps can't pay. And maybe there's a financial issue. What you want at this stage is to find out those reasons. So you're not wasting resources, for example, running off to court if in fact there's a financial or other reason why they can't pay, in which case there might be an arrangement you can make.
And part of that information gathering process is you can do searches online. A simple one is you can type someone's ACN into the ASIC website, and you'll be able to see, for example, if their company's deregistered or in liquidation, at which point, you know, you may have a genuine debt claim, but if their company's gone under, it may just mean there's nothing left in the pot for you, or a different process to follow to try and get that sort of small amount out of it. Other searches you can do is property type searches, asset searches. If you can figure out that someone owns a lot of property, then perhaps, you know, even if the company's struggling, you might still think it's worth putting pressure on them, particularly if you've got personal guarantees to rely on. And even Google searches about the business name, you can often find a bit of gossip almost about what's going on, about, you know, if a company's struggling or in strife, or you can see, you know, a lot of court action will be sort of published online. So you'll see if there's other people taking action against someone. So it's always good just to do a bit of research and figure out, is it going to be worth chasing this debt, or, you know, dedicating more of my resources, knowing that, you know, balancing the spending of resources to sort of escalate it legally versus there may be a chance that there's nothing there at the end of it. You're throwing good money after that type of thing.
Usually what happens, again, debtors will do one of two things. They'll either go to ground and put their head down, and if they're really having trouble paying, it's not uncommon to hear nothing from them at any stage. You might find that they've gone quiet, they're not responding to any communication, and we see that sometimes once we do escalate things to legal action, formal demands, court claims, not a peep from them, and that's how you go down the court path. We'll touch on that briefly a little bit later, but we're not going to go into a lot of detail in terms of what happens in court. But for the other people who do come back to you in some way and give you some information, this tends to happen probably in most matters that we work on, most debt recovery matters. In some way, the debtors put their head up. And in more cases than not, there's a reason why they can't pay. Now, it might be a cash flow issue generally. It might be that they're just not able to pay for some reason the full amount in one go.
And you're seeing it a lot with, you know, the post-COVID economy. A lot of companies are struggling. So there've been sort of certain pauses on certain court procedures. So everyone's been hibernating for the last year, and now everyone's, you know, starting to catch up those debts, and debtors are saying, look, you need to give me some breathing room. I'm fighting off a lot of creditors. So it's a question of thinking about, well, is it more in my interest to compromise here and accept a lesser sum, or accept a payment plan or something along those lines, as opposed to, you know, going guns blazing and going all the way to court, etc. If there's not necessarily a great chance you'll get all the money back at the end. In most of the matters that we deal with, I would say the majority end up in some form of negotiation with debtors, perhaps offering some kind of instalment plan, some kind of compromise offer. And more often than not, particularly for smaller debts, you know, we would urge clients to keep an open mind about that, because ultimately any money that you can get into your pocket is going to be worthwhile, and it's generally going to be a better option than refusing any kind of offer or compromise and wanting to wait for the full amount and go to court, because there's no guarantee you're going to get that full amount. So again, it comes back to that idea of keeping those lines of communication open, find out what's going on, find out what's the best they can offer. You can consider it. You don't have to, you know, make any decisions about that on the spot. Obviously, a decision for your business, and if you've got multiple debtors, then that's
might be something that your business can't afford to carry. So it'll be a case-by-case basis. But as a general principle, we'd urge to keep an open mind and hear out those type of negotiation discussions to see what might work for you.
And then, especially if it's a bigger debt, compromise, you can be creative with a compromise. It might be ultimately a good deal for you, even if you're accepting a lesser sum, for example, if you wrap it up in essentially a new agreement where it's covered by a personal guarantee, which I love to come back to because it's just so much, you've just got so much more security if instead of just chasing a company which is financially in trouble, you've got a new agreement that says, the company will pay in this installment plan or something along those lines, and also there's a guarantee. So yeah, it's always worth sort of thinking about, is there a deal that suits everyone? They're genuine about wanting to resolve it, but they can't right now. Can you ask for something as a further concession from them in exchange for you making a concession? So yeah, there's always, I mean, doing this work day to day, it's very rare that we just either go all the way through the court system and get a full payout, or yeah, it's sort of you might get paid right away when you're applying a bit of pressure. You might negotiate a deal, which is perhaps involves some compromise, and then it's very rare that you go all the way through the court system. It can be done, and again, it's case by case. It depends on the size of the debt.
When you get to this sort of negotiation stage, depending on the size of the debt and your business and what's involved, if you're prepared to consider some kind of settlement option, and if it's a larger debt, this might be the point where you want some legal assistance, because we would recommend, if you enter a new agreement, we call it a deed of settlement, that you get a lawyer to help draft it. It's a pretty simple document from our perspective. It's not usually complicated, but what it means is that, for example, just say you've got a 100 grand debt that you've agreed they can pay it out over a year. You want set repayment dates, because you want to make sure that if they default on any of that, you've got a pretty simple legal process to follow them up. You don't want to be caught in endless admin and chasing yourself. And a deed of settlement can make that, give you some protections, possibly adding a personal guarantee. That's something that we can help with, and we do a lot for clients to just arrange payment of debts without having to go to court.
Something on a slightly different note that I want to touch on is at what point you might want to send a lawyer's letter of demand, which, I mean, we talked about earlier. You can have your own processes where you send out a demand when an account is overdue. I mean, most people in business have probably seen a lawyer's letter of demand that just says, here's the debt, here's why the debt's owing, 14 days, 28 days, otherwise we might sue you. It's an escalation tool. If your attempts to sort of discuss things amicably aren't working, you might just want to be a bit more to the point and sharp about it. You might want to get a lawyer to send that letter because it carries a bit more weight in terms of the threat of further legal action. Sometimes the letter's enough to bring them to the table and get them to negotiate because they sort of realise you're serious about it. I mean, other times if you send a letter yourself, that might be sufficient. But in terms of how we think about these things, it's sort of step by step, and you're always thinking, what can we do to escalate pressure, to ratchet up the pressure? So if you're not getting anywhere, you send a legal letter of demand. If that opens the door to negotiation, great. If it doesn't, you then potentially want to escalate to the next step, which would be court action.
And a formal letter of demand is needed as part of any claim that you make. You need to be able to show the court that you've given the other side a fair heads up and proper notice of the debt that's owed. So again, that's something that you might want a lawyer to do. We do find a lot of debtors who've been very quiet or gone to ground will put their head up when they see a lawyer's letter. That does make some difference. And it does refer to court proceedings at the end, and it has a firm deadline. So that's kind of the last step that you can take really before before having to escalate to court proceedings. And again, whether you do that yourself or if you ask a lawyer to do it, it is usually a fairly straightforward process. And from that point, we then advise clients, if we're engaged at that point, to have a look at all the information that's there and to consider whether or not to go to court. And that's really the point where you then look ahead and see what might be involved next. Is it worth it for the costs and the time and the likely outcome?
Yeah, and again, we'll only touch on the court aspect of this relatively briefly, but something that's useful to think about is if it's a genuine debt that's owing and there's no dispute, as we sort of flagged as a bit of a different scenario, there's no dispute, going through court and getting a judgment is actually a really straightforward process. It's just paperwork. You fill out paperwork, you file it, you serve it on the other side, you wait some time, depending on the court, and then if they don't put in a defence, which in theory they won't if there's no argument that the money's not owing, then you basically get a rubber stamped judgment from the court called a default judgment. The key thing to note though is that's not the end of the story. It's all sort of almost a formality getting there. Getting a judgment then opens up a range of different options to you, enforcement options, which I won't get into all of them, but for example, you can try and garnish money from a judgment debtor's bank account. You can send the sheriff around to their properties to try and seize assets. You can even get the ball rolling in a big long legal process that would have a company wound up in insolvency or bankrupting an individual. So there's a whole that's where the sort of complexity arises in bigger debt recovery matters, is thinking about enforcement and thinking about how you can do that strategically as a way to continue to ratchet up pressure. And in our experience, certainly in the context of smaller and medium business, it's still usually worth settling, even if you're halfway through a court procedure and you're sort of dialing up the pressure. It's still probably better to get some kind of settlement deal that's workable than to kind of go all the way to the end and get a judgment, and then you might actually have some difficulty enforcing that judgment if you don't have information about their bank accounts, or there's no money in their bank accounts, or they don't personally own any assets that can be seized, etc., etc.
The other way we sometimes look at court proceedings, if it's appropriate for a matter, as issuing the first application or claim, which is usually a statement of claim. It's a little bit different in different states, but the same process applies. And if it's a straightforward debt, it's usually a pretty simple matter to draft and prepare. And you can file that in court and serve it on the debtor in accordance with the court rules. That process in itself can sometimes scare the life out of people. We kind of refer to a lot of these steps in debt recovery as like shaking an apple tree, and you can shake harder at different stages and hope that some apples will fall out. And we do see some clients have some success with, they'll have nothing from their early stages of following up, nothing from their own letter of demand, nothing from a solicitor's letter of demand. But the minute a process server serves them with formal court documents, they'll pick up the phone and see what kind of deal they can make or what they can do. And you have the option then of stopping those court proceedings. Court proceedings will get expensive and unwieldy and out of control if the other party files a defence and says that the debt's not owed, and that's when you move into dispute territory. And again, that's probably another webinar, but it's
but going back to the initial thing we said about, you're trying to flush out information early, figure out if there is a sort of disputes or grounds for a dispute. You can't guarantee, even though you've never got a response, that they won't suddenly turn around and dispute it while you're in court. So going to court can be inherently risky in the sense that they do get an opportunity to respond. Once the trains leave the station with the court, it's hard to get off, and you're not fully in control of the process, and that's how costs add up. There's all sorts of twists and turns and extra information you have to provide and argue about. At that point, legal fees add up, and so that's all part of the calculus when you're thinking about the cost benefit of debt recovery proceedings. And it's very much depends on the individual circumstance because there's so many different variables. But I mean, it's some super ballpark because it's not that often that we go to court for claims under 10,000, even if they're not contested, just because it's just not worth it often from a commercial point of view. But again, it depends. There are also some, for example, in New South Wales, the small claims division of the court. Some of the tribunals in other states have a debt recovery sort of jurisdiction. So there are sometimes more user-friendly processes that have been designed to be accessible for non-lawyers to try and recover a smaller debt. So that's always worth exploring. If it's a smaller debt, there are kind of DIY options. Yeah.
Look, I think that's probably as much as we need to cover talking at. You were happy to answer some questions now. We've been sent a few.
Yeah.
The first one, can I recover debt going back a year or more? Yes, you can. The limitation period for general debts is 6 years. So you certainly can for that.
And there's different statutes of limitations, statute of limitations in every state, which sets up the rules of, how long you can wait before going to court for something. Some documents, deeds, which are different to contracts, have a 12-year limitation period. So often personal guarantees are deeds. So often you can rely on a personal guarantee for a very long time, which is good to know. That's why I like personal guarantees. Second question. To what extent can we use social media like Facebook in chasing the debt?
Good question.
Good question. Not recommended in most cases. If you are posting anything about a third party in any public forum, be it Facebook or just any social media really, you might expose yourself to someone arguing that you've actually defamed them.
We've got a matter on at the moment where that's actually going on. It's a debt claim, and the person claiming the money has arguably defamed the other party by telling the world that they owe the money. And
they copied in an email trail. They were sending a pay the money email, but then they copied a whole bunch of unrelated parties in. And so that then said, well, if we dispute the debt, then what you've said in this public email wasn't true, which gives us a separate legal cause of action. And it's messy, let me tell you, it's a messy situation.
So best to keep it offline or private communications. If the way you deal with that party is by direct message by Facebook, then that's appropriate, as long as third parties aren't able to view it.
As long as it's not a publication, which is sort of anything that's in the public domain essentially, or accessible by a third party.
So this question is, I sit on the other side whereby I'm interested to know how best to demand when suppliers have invoiced correctly or overbilled. So I think for any business who's issuing invoices and they're not being paid, the same issue applies. If the other party says, well, hang on a minute, I'm not paying that because I think you've invoiced me incorrectly. Our answer here is exactly what we said about keeping the channels of communication open. Absolutely share information, make sure those details are correct. If you've been provided with an invoice that you think is incorrect, then question it and make sure the details are correct. We call that narrowing the terms of a dispute when it comes to us. And that type of information sharing, again, when done without any unnecessary aggro, can resolve things really quickly.
Because it might technically be a dispute in the sense that you're disagreeing over what's owed, but if it's something that you can actually get to the bottom of and figure out, actually this line item on the invoice isn't quite right, you may be able to resolve that dispute without escalating into sort of a legal dispute. Another thing to keep in mind as well is often if the debt's arisen in relation to a contract, a service agreement or something like that, there can be a dispute resolution clause which sets out a process that says, if one party has a problem with what they've been invoiced, the first thing you need to do is get in contact or send a formal notice or something along those lines. So there'll often be a little formal procedural part of an agreement that encourages the party to resolve these things by way of communication and says that you actually can't go to court until you've followed through the agreed steps. So in the circumstance if you think you're being overbilled, probably the first thing to do is look at your contract and see, is there a dispute resolution process? And if so, follow it.
There's a question, is New South Wales the same as Queensland?
No, they're different. But in terms of the work we do, they're similar enough. There's different rules in all of the different courts, but in principle, the systems operate in a really similar way. And the different nuances of the different state systems, every case has a lot of variables in terms of facts and the size of the debt and the companies involved and the parties involved. The difference between what jurisdiction the debt arises in is just another sort of variable to work through.
So pretty much everything Simon and I have talked about today in terms of early steps and the general principles of knowing the parties and getting the contract right and initial communications, that's all quite universal information. The jurisdiction part really comes into play past a letter of demand stage. So if you're looking at going to court, the different states, and that's not just New South Wales and Queensland, but all of the different states have a different tribunal type arrangement, some courts, they're called all different things. It is quite confusing. They have different small claims type divisions.
Yeah. To give an example there, in Victoria, VCAT, the Victorian Civil and Administrative Tribunal, covers debt recovery. It's actually really user friendly. You can kind of log a debt recovery claim just through the website. It's a really straightforward process. Lawyers don't need to be involved. In New South Wales, the tribunal doesn't cover pure debt claims. You'd often have to go to the small claims division of the local court. So these are the sort of variables we're talking about. You've got to work through an individual specific case, but in principle, it's going to be similar. You're going to be looking at the contract. You're going to be looking at where the debt came from. You're going to be looking at who the parties are. You're going to be thinking about how you can escalate. Those sort of general principles still all apply.
Another question here, I'd like to know what my options are if I have a customer on a payment plan that I manage myself and they just don't pay. I don't usually order the products or deliver it to them until full payment is made. Well, there's a few things going on there, and it sounds like mostly you're managing it very well yourself, but it might be that you're prepared to draw a line under when the non-payment is a problem for your business. You've obviously been able to manage and let them go for a certain period. I think it would be important to communicate clear deadlines so that you let them know that there'll be a point where you're drawing a line in the sand and give them a clear deadline for payment and let them know that you won't be able to provide any more services, and perhaps a point beyond that where you, depending on how much you want to escalate or add pressure, that you will be seeking legal advice, that you might want to recover the full debt owed and you're not prepared to continue business on that arrangement. Or alternatively, if there's a large amount owed, that you might want to make that payment plan more formalised, and you might want to get some advice about a deed of settlement type arrangement that spells it out and makes it very clear rather than a moving feast of ongoing dates and emails, which can get a bit confusing and can be a lot of work for a business to keep track of.
Yeah. Next question. What can be done after getting a VCAT judgment and still not being able to recover from clients? So this is what we touched on earlier. Getting the judgment can be somewhat a formality if the other side's not going to argue about it. But then, yeah, there's a whole range of steps you've got to take after that. With VCAT, the first thing you'd have to do is register it with the Magistrates Court in Victoria, and then you'd need to potentially send a statutory demand alongside the judgment, which says if you don't pay this judgment in 3 weeks, you've committed an act of insolvency, which then means that you could, if they don't, apply to have the company wound up in insolvency, which is a sort of 2-3 month of court procedure and so on. That's just one option. So if it's a significant debt, this is probably the point, not to sort of spruik our services, but this is the point you probably want to have a chat to a lawyer. What are my options, and what's something? What can I strategically do that's commercially sensible to try and recover this judgment? Because it's not the end of the story, unfortunately. In some regards, it's the start of the story.
The other thing to keep in mind, if you do end up in tribunal or court proceedings and you end up with a judgment. So a judgment in, as Simon said, a smaller tribunal like VCAT or the New South Wales version, which is NCAT, can be formalised and registered in another court. But a judgment can be quite a hefty tool in and of itself, because once a judgment is entered against a company or an individual, then it affects their credit rating. The credit ratings agencies have means of monitoring court judgments, and they will apply that automatically. So your debtor, if you might not have your cash yet, you might have just got to the point where you've been able to get a court judgment against them, but they might find that they're not able to get any additional finance for their business as a result. So a judgment in and of itself can really stop some businesses in their tracks if they're still trading, or if they're having some financial difficulties and wanting to get more finance. We do find that in many cases, but otherwise it's a question of looking at those enforcement options.
And we've been on the other side of that a fair amount, where companies have got judgments against them, and then they say, hang on, this is damaging my credit, what can I do? And so that then turns into a process of you need to negotiate with the other side and say, well, I'll pay the debt if you agree to have the judgment removed, which they don't necessarily have to do. So it is actually a good leverage point if the debtor cares about their credit.
Question, we have a few small debts ranging from $150 to $500 from about 8 to 10 people. Is it worth going to a debt collection agency?
Well, it's good to talk about debt collection agencies, actually, because they're different to what we do. They'll usually, you can sell them your debts, or they'll work on a commission basis. So it can be a really low cost way to have someone act as your agent to do those early follow-up steps of calling and emailing, and they can be quite persistent and annoying. The thing is, with the debt collector, if they're not successful at just chasing someone, they usually, what they'll usually do is refer to a lawyer to actually take it through the court system. Like, they don't have any sort of additional powers that ultimately have to follow the same process. So what that means in terms of cost benefit is smaller debts, unfortunately, often there's no commercially viable way to pursue them. I mean, you might be able to outsource it to a debt collector on a no-win, no-fee basis or something, where they sort of keep the majority of it if they recover it. But yeah, from a pragmatic point of view, debts of that size, 150 to 500, are often considered bad debts just because the sort of resourcing you'd need to pursue them isn't worth the time and money.
So I guess it's a commercial decision for your business. If there are enough of them that doing any of the initial chasing that we've talked about today is just an administrative burden that your business doesn't have the resources to cover, then a debt recovery agency, depending on the type of fee arrangement that they're offering, might be a good outsourcing option for you. But they can come with their own hidden costs. So it's worth having a good understanding of how they charge. And yeah, they're not really going to be able to do any magic that you probably couldn't do yourself.
Alrighty, next question. I often structure my project fees as 50% upfront and 50% on completion. What potential issues should I be aware of when structuring this way? Well, I think in an ideal world, you'd get paid upfront and then you'd never have to do any debt recovery. Getting 50% upfront is also better than getting nothing upfront. What you can charge, how you can structure your payments is So, it'll depend on your sort of bargaining position and industry standards. Some industries you just might not be able to get away with payment up front. Other industries, you might be able to do it. The more you're having paid after the services or goods are delivered, the more exposed you are to a debtor not paying you, and then you having to invest time and resources into pursuing it. So it's a balance of commercial considerations, really. Should I make it all up front and perhaps have it at least sort of sweet deal for the client, or should I, allow them to pay some afterwards, but put a bit of, I accept a bit of risk there because I might have to take steps to recover. Flowing from that, say your service is a $500 job, and you know that chasing $250 isn't going to be worth it commercially. That might mean that it's smarter to get payment up front for a transaction of that size. On the flip side, if it's a $50K job, sure, pay the balance, pay 50% balance on completion, and if you don't pay it, it's probably worth pursuing 25 grand in the court system if need be.
We see a lot of those sort of contracts that end up in disputes between the parties. Obviously, lots of construction type contracts and software design type contracts will have staged payments like that. And very often the disputes are around what work was provided and when, because what seems to happen for a large scope of work is that there are often changes to that scope, there are variations. So this is probably less a debt recovery issue, more of a contractual and avoiding disputes type arrangement. But from the type of disputes we see, our advice from the beginning would be to try and make sure you've got things documented very clearly, that any invoices that you're issuing very carefully reflect any initial contract and scope of work, that any variations or changes are very clearly documented so that the person receiving the invoice won't get a surprise. All of those things will increase the likelihood that the person receiving the invoice, well, if it's not clear, that they're going to dispute it and get into a payment dispute. So it's more a question of having your paperwork in order and really clearly spelled out and documented.
Yeah, cool.
We're done.
Yeah, looks like we're that's the time. Couple of housekeeping things. We've got a debt recovery guide, a nice PDF you can download. I think it's circulated in the browser. And
if anyone has any other questions about debt recovery or that our team might be able to help with, there'll be a link coming through and a survey, I think, following the webinar with a link for a complimentary consultation with the team at LegalVision that we can help with all of the sorts of questions and information that we've given today. But thanks for your time.
Yeah, thanks for tuning in.
To give you some tips to get started and get some of that cash rolling in.